Hello, I'm Brian Schneider with Mid-Hudson Injury Law, and today we're going to talk about something a little different, more about current event or current issue, which is pervading the news this week particularly. It involves the social media addiction trial underway in California. The plaintiff in that case is now a 20-year-old young woman who is claiming that the platforms, in particular Facebook or Meta and Google through YouTube, are basically product defects, or they were designed defectively. And this was also done by design by her lawyers. This is basically a personal injury case that's underway for this matter. And that in part may be due to the fact that the social media platforms have enjoyed liability protection under a certain provision of the a federal law. It's known as Section 230 of the Communications Decency Act. And the tech companies have generally been protected from liability by that statute. And what that does, again, generally speaking, is protect them from what users of their platforms post online. This lawsuit, and I did not read the pleadings, but I've read and seen probably a lot of the same things that you have, is styled as a negligence complaint, as a negligence lawsuit. And this is not something that's embraced by the federal law. So the plaintiff and her attorneys are seeking to be compensated for the injuries that the social media platforms have caused her. And what she's basically arguing and presenting in this case is that the platforms intentionally engineered their products to be addictive, particularly for young children. This particular plaintiff is arguing that she started using certain platforms as young as 6 and really got hooked around the age of 9. You can imagine that the defense to this case is going to be pretty vigorous. YouTube has a defense different from Meta, but Meta is basically going to argue that it's not social media that caused this young lady all of her problems, that they're being scapegoated, and that this young lady had, unfortunately, a history of abuse and bullying and neglect, which is, at least to some degree, reflected in her medical records and through deposition testimony that was elicited throughout the pretrial discovery proceedings in her case. I also read that Facebook's lawyers, or Meta's lawyer, argued in his opening statement that they're going to try and discredit the social media addiction as an actual scientific concept. So they're digging in pretty aggressively, as you would expect, because the stakes are high. I don't know if these parties are planning for appeals or any post-verdict practice that might come about depending on how this all shakes out. But I have to believe that the sides are both well-funded and they're probably prepared to go the distance regardless of who wins and loses, at least at the trial level. There are a couple thousand other cases pending throughout the country in both federal and state courts. They don't all mirror what's being pled and argued in this personal injury case, in this defective design case in California. For example, the city of New York filed a lawsuit in federal court, essentially looking to be compensated by many of the platforms for the money its health system has had to pay out for the deleterious effects, the detrimental effects of social media, whether it be mental health treatment or physical, medical care. We've all seen online how kids will take up crazy trends, subway surfing trends. There was a story out of New York City this week where a child was stuck in a rafter of a bridge or some part of a bridge as part of some sort of online stunt or some sort of online trend that was becoming viral. And the healthcare systems are footing these bills, and oftentimes those systems are being funded by public money. So that's just one of many, many other examples of how parties, not just individual people like the young lady in California, but state governments and city governments and other agencies of government are seeking to hold social media platforms accountable for the content and the engineering and design of their platforms. To shift back to what's happening in the California case, I read that the plaintiffs there found some internal documents from Meta and from Google showing that at least some personnel at those platforms knew all too well what was being done to snag and ensnare young, vulnerable children to keep using uh, their products, keep using your applications. And you don't have to be a parent to know about how some of the stuff can be really eye-catching, whether it be beauty filters or the autoplay features of videos or things like the infinite scroll. It can just go on and on and on. And you see that in any number of platforms, whether it be social media or other places. So YouTube um, is in addition to presumably adopting a lot of the same defenses that the Meta lawyers are putting out there in the California case, they're arguing that they're not even a social media platform, that they're a video sharing platform, that they're not like Meta and Snap and Instagram. Just to be clear, TikTok and Snap actually settled their claims with the young lady plaintiff in the California case. Terms haven't been disclosed, but they're out of the case. But nonetheless, what happens in this California matter stands to be a real bellwether, and it's setting up what could be, a very important precedent for cases like it, not just in California, but across the country. So this is something that definitely bears watching. And I'm going to invite anyone who's watching this video to offer their perspective and their opinion in the comment section. I haven't usually invited this, but I'm curious to see what any viewers of my videos might think about this. Are the plaintiffs in this case looking to scapegoat the platforms and blame them for all their problems? Or do you believe or agree that the platforms bear some responsibility for the product that they put out there, especially when you consider some of their very alluring features that are going to be very addictive to young minds? Please tell us what you think. I would be very curious to hear what you've got to say. I, I'm unaware of any similar personal injury or product liability case pending in the state of New York that might have this type of presentation. You can probably suspect that if the California case is successful, that this could pave the way for such things. I'm not going to offer any opinion as to whether or not I feel that's bad or good. This is an evolving subject. A lot of people, myself included, think sometimes that maybe society moves so too quickly and it takes a while for people to catch up, for that whiplash effect to kind of wear off. But nonetheless, that's not an excuse to wash your hands of what your young children might be doing in their spare time in their rooms with their doors closed. Parents, should be involved and should be really aware of what's going on and not just look to cast blame. I'm not suggesting that the parents in the California case were remiss or they weren't involved. I really don't know. I am just kind of parroting what I think are some of the general themes that come up in this conversation. But it's more than a conversation now. It's a real case, and a jury's been impaneled, and opening statements have been given. And there was testimony already yesterday from Mark Zuckerberg, and he was at times pretty combative and defensive. And I can't say I blame him. He's going to be under the microscope and under the gun financially and legally for some time. And again, without offering any perspective or opinion as to who's wrong or right, no one can necessarily blame the man for trying to defend himself. Regardless, it's his right to do that in the system. And he has every opportunity to try and explain himself and offer a defense of the case. I think it's going to be a tough road to hoe. It's hard to know where public sentiment lies on this issue. It can be a bit of a mixed bag, like it is with so many other things. But it's interesting, and it's further attention and time, and we'll keep our eyes on it as well.